There's a number attached to this trial that you've probably already seen. $1.4 trillion. It's been in headlines for a week. It's been in thumbnails. It's been in the mouths of people explaining, with total confidence, that 4 American states are trying to take $1 trillion from Mark Zuckerberg. Here's the problem. The states aren't asking for $1.4 trillion. That's not a technicality, and it isn't my opinion. On the opening day of the trial, California Attorney General Rob Bonta stood in front of reporters and said it directly. They are not asking for $1.4 trillion. He's the man leading the case, and the number everybody's repeating is not the number he wants. So where did it come from? It came from Meta. Meta's own attorneys produced that figure. They took the state's theory of penalties, ran the arithmetic out to its absolute ceiling, arrived at $1.4 trillion, and put it in front of the court. The press picked it up and ran with it, which is understandable because it's a genuinely staggering number. The state's own lawyers told the judge that $200 billion is the more realistic figure. That's still one of the largest civil penalties ever contemplated against an American company. It's still enormous. But it isn't the number in the thumbnails. We're going to walk through where that trillion actually comes from, because the arithmetic behind it is fascinating, and almost nobody has explained it properly. But the money isn't why this trial matters. This trial matters because of a legal maneuver that took 10 years to build, and that has already survived every attempt to kill it. If it works here, it doesn't just cost Meta money. It removes the shield that has protected every social media company in America since 1996. That's the real story, and it deserves a proper telling. To understand $1.4 trillion, you need to understand how civil penalties work, because they don't work the way damages work. Damages compensate a victim. You were harmed, here's what it cost, here's a check. Civil penalties are a different animal. A statute says that if you break this rule, you pay this amount for each violation. And then the whole thing turns into a counting problem. How many violations were there? We don't have to guess at how that plays out, because it already happened this year, in New Mexico. In March of 2026, a New Mexico jury found Meta liable for violating that state's consumer protection law. The maximum penalty available under the statute was $5,000 per violation. The jury found there were thousands of violations, and they went to the maximum on every single one. The final figure was $375 million. One juror later explained how they got there. The jury had compromised on the estimated number of teenagers affected, but once they'd settled on that number, they applied the statutory maximum to each one. She said she thought each child was worth the maximum amount. That's the machine. Penalty per violation, multiplied by the number of violations. Now scale it up. New Mexico is a single state with a population of roughly 2 million. This federal trial involves 4 states arguing on behalf of a coalition of 29. California alone has around 39 million people, and the claims include violations of the Federal Children's Online Privacy Protection Act, known as COPPA, where every account belonging to a child under 13, collected without proper parental consent, is potentially its own separate violation. Run that multiplication across 4 states, across more than a decade of operation, across millions of accounts. At statutory maximums, you get $1.4 trillion. Here's the honest part. That figure is real arithmetic. Nobody invented it. Under a maximalist reading of the statutes, that's genuinely where the maths lands. It's also never going to happen. Meta is currently valued at roughly $1.5 trillion. A judgment of $1.4 trillion wouldn't be a fine, it would be the end of the company, and courts don't hand down penalties that liquidate a defendant in a civil consumer protection case. Which is exactly why Meta calculated it and handed it to the court. A number that absurd is an argument. It says, look what happens if you take their theory seriously. It's a way of making the other side look unhinged before a single witness has testified. And then it escaped the courtroom and became the headline. Watch what the states did in response. They didn't embrace it. Bonta went out of his way to disown it, and framed the case as being about restitution rather than damages. Their own lawyers handed the judge a far smaller figure. Plaintiffs don't usually talk down the money they might win, unless the money was never really the point. In 1996, the United States Congress passed a piece of legislation containing 26 words that would go on to shape the entire architecture of the Internet. Section 230 of the Communications Decency Act. The core idea was simple, and at the time it was sensible. If a website hosts content that other people wrote, the website isn't treated as the publisher of that content. A message board isn't responsible for what a stranger posts on it the way a newspaper is responsible for what it prints. Without that rule, the modern internet doesn't exist. No comment sections, no user uploads, no social platforms at all. The liability would be unmanageable. But the courts interpreted it broadly, very broadly, and for 2 decades it worked as something close to an absolute shield. Here's what that meant in practice. Somebody sues a social media company. The company's lawyers file a motion, and the motion says, in effect, this lawsuit is about content that users posted. Section 230 says, we're not liable for that, so dismiss the case. And the case would be dismissed, before discovery, before a single internal document was produced, before anyone testified. That's the crucial detail, and it's the one most people miss. It wasn't that the platforms won these cases, it's that the cases never happened at all. The shield operated at the doorway, which meant you never got inside the building. For 20 years, that was the pattern. Grieving parents, school districts, state regulators, all of them ran at the same wall, and the wall held every time. So the lawyers stopped running at the wall. They started looking for a door. The argument that finally worked is deceptively simple, and once you've heard it, you can't unhear it. It goes like this. We're not suing you over what your users posted. We don't care what your users posted. We're suing you over the thing you built. Infinite scroll isn't user speech. Nobody posted infinite scroll. An engineer at the company designed it, a product manager approved it, and it shipped. The same is true of autoplay. The same is true of push notifications timed at deliberately unpredictable intervals. The same is true of the recommendation algorithm that decides what appears next. And the same is true of the like button. Those are engineering decisions. They're product design choices, made on purpose, by the company, for the company's own reasons. And product design is something you can absolutely be sued over. The analogy the plaintiff's lawyers reach for is the car. A car manufacturer can be sued for defective brakes. It doesn't matter that people have conversations inside cars, and it doesn't matter that those conversations are protected speech. The brakes are a product, the product was defectively designed, and the manufacturer is liable for the product. Now apply that to software architecture. If a company built a system it knew was harmful and then deliberately tuned that system to deepen the harm, the plaintiffs say, that's a design defect, and Section 230 has nothing to say about it, because no user speech is involved in the claim at all. That's the workaround. Sue the architecture, not the content. The obvious question is whether it holds up, and this is where most coverage stops, which is a shame, because it's the most important part. It's been tested repeatedly, and it has largely held. Judge Yvonne Gonzalez Rogers, in the Northern District of California, ruled on this in 2023 and again in 2024. She largely agreed with the design defect framing and let the litigation proceed. In November of 2023, she ruled that Meta and the other platforms would have to face negligence claims, rejecting both the Section 230 argument and a First Amendment argument. In California State Court, Judge Carolyn Kuhl reached a similar conclusion in a separate consolidated proceeding. She found that neither Section 230 nor the First Amendment shields these companies from liability for their own app features, because the claims target design elements rather than third-party content. And then, this month, the Ninth Circuit weighed in. A 3-judge panel issued a 24-page opinion written by Circuit Judge Jacqueline Nguyen. The holding was procedural, and it was devastating for the platforms. Section 230, the panel said, provides a defense against liability. It is not an immunity from being sued. That distinction sounds like lawyers' small print. It isn't. It's the entire ballgame. and immunity gets you out at the door. A defense is something you have to stand up in open court and argue, at trial, after discovery, after your internal documents have been produced, and after your former employees have testified. The wall didn't fall. It got demoted. It stopped being a gate and became an argument. The same panel also denied Meta's emergency request to delay this trial. The scale of what that unlocked is worth sitting with. More than 3,000 federal lawsuits, plus roughly 3,300 more, consolidated in California state court against Meta, Google, TikTok, and Snap. But here's the honest caveat, and we're not cutting it. The workaround isn't a clean sweep. In those same 2023 and 2024 rulings, Gonzalez-Rogers found that Section 230 did limit a number of the claims, including some that concerned specific platform features. When Meta moved to dismiss the state Attorney General case in April of 2024, she denied that motion for the most part, but she placed limits on the state's claims, and she acknowledged that Section 230 still offers the company some protection. Section 230 isn't dead. It's been narrowed, the narrowing is contested, and the higher courts haven't had the final word. Anyone telling you this trial killed Section 230 is running ahead of the evidence. There's something else that happened before opening statements, and it's the single most underreported fact in this entire story. Meta had already lost part of this case. In her summary judgment ruling, Judge Gonzalez-Rogers found that Meta failed to comply with COPPA's notice and parental consent requirements, the rules that govern collecting personal data from users under the age of 13. She granted summary judgment to the states on that issue, which means it doesn't go to trial. It isn't in dispute, it's decided. What remains in dispute, and what this 6-week trial is actually about, is a much narrower set of questions. Are the platforms addictive? Did Meta falsely deny designing them that way? And did the company market them at least partially toward children? Gonzalez-Rogers found material factual disputes on all three, and that's why there's a trial at all. Her ruling explicitly did not decide whether Facebook or Instagram are addictive, and it did not decide whether they cause the alleged harms. It decided only that reasonable people could disagree, and that the disagreement should be settled with evidence. That's a far more modest thing than most coverage implies. It's also the first time those questions have ever been put to a federal fact finder with full access to Meta's internal record. The state's first witness was Arturo Béjar. Béjar worked at Meta in product safety across 2 separate stints, roughly 8 years in total. He was an engineering director. He wasn't a junior employee, and he wasn't an outsider. Meta tried to stop him testifying. The judge refused, and she described the attempt as a Hail Mary to eliminate a strong witness for the plaintiffs. Here's what he told the court. He testified that he had helped build internal studies that surveyed how often users, including young users, reported encountering harmful material, bullying, self-harm content, violence, real numbers, gathered by asking users directly about what they'd experienced. He testified that instead of publishing those results, Meta released a different set of metrics, estimating how often content violated company policy. Those two things aren't the same. A piece of content can sit comfortably within policy and still be experienced as harm by the person who sees it. His assessment of the published numbers was blunt. He said they created a false impression of safety. He described the company's posture toward child safety as, "Don't ask, don't tell." He testified that during his second stint, between 2019 and 2021, the company started substituting the phrase problematic use for the word addiction, a framing he said fell short of the thresholds academic researchers actually use. And he testified that in 2021, after Zuckerberg publicly said the company doesn't prioritize profit over safety, Béjar emailed him directly. He said he felt Zuckerberg had created a false and misleading impression of Facebook's commitment to young people. He estimated he had briefed Zuckerberg on product issues at least 100 times. That's testimony. It's one witness, under oath, giving his account, and it hasn't yet been through full cross-examination. Meta disputes the characterization entirely. Which brings us to the other side of the room. Meta denies the allegations. The company's position is that the state's claims are unsubstantiated, and it points to its record on teen protections, including enhanced privacy settings for young users and a 1-hour timer on Instagram that prompts teenagers to close the app. In court, Meta's attorney Paul Schmidt made an argument that's more effective than it might sound. He said the states were cherry-picking, pulling individual data points and statements and studies out of an enormous internal record and presenting them stripped of context. He argued that Meta was well aware of the risks to young people and made meaningful efforts to address them. His framing was that Meta has been openly discussing the fact that some people struggle with social media for years, which isn't the behavior of a company concealing a known harm. There's real force in that. Meta generates an extraordinary volume of internal research, and in any body of work that large, a motivated litigant can find alarming individual documents. The question is whether those documents represent how the company actually behaved, or whether they're simply the most quotable fragments of a much larger and far more ambivalent record. Meta has also consistently rejected the causation argument. The company's position, stated plainly in the Los Angeles case, is that it doesn't believe its platform is responsible for the teen mental health crisis. That's not a trivial defense. The teen mental health crisis has many proposed causes. The research literature genuinely is contested, and proving that a specific product feature caused a specific harm at population scale is difficult. The states have to prove it. Meta only has to leave the judge uncertain. Meta has already been to trial twice this year on related claims and lost both times. New Mexico, March of 2026. A jury found Meta liable for consumer protection violations relating to child exploitation on its platforms and imposed $375 million in civil penalties. The state had asked for more than $2 billion. Then, in a second phase, the judge ordered Meta to pay a further $567 million into a harm abatement fund, finding that the platforms were a significant contributing cause of the teen mental health crisis in that state. The judge also ordered operational changes, time limits for underage users, hiding likes on minors' photos by default, visible risk warnings, total exposure, $942 million. Los Angeles, also March of 2026. A jury found Meta and Google negligent in the design and operation of their platforms. In a personal injury case brought by a young woman, the court identified only by her initials, who testified that she began using the platforms compulsively as a child. The award was $6 million, with Meta responsible for roughly 70%. That jury deliberated for more than 40 hours across 9 days. Now put those numbers in proportion. Meta's annual profit in 2025 was approximately $60 billion. Revenue was around $201 billion. $942 million is a rounding error against that. When the New Mexico verdict landed, Meta's stock went up in after-hours trading. Shareholders read it as good news, because the number came in at less than a fifth of what the state had asked for. That's the context for the trillion-dollar headline. The financial penalties so far have been survivable to the point of being shrugged off, which is exactly why the states are talking about restitution and remedies instead of damages. There are some structural facts about this trial that most coverage has skipped entirely, and they change how you should read the next 6 weeks. There's a jury, but it doesn't decide the case. 8 jurors were seated, and they are an advisory jury. Judge Gonzalez-Rogers makes the ruling. The jury exists to give her a read on how ordinary people weigh the evidence, and she is not bound by what they conclude. It's the same arrangement she used earlier this year in the case Elon Musk brought against OpenAI. The trial is expected to run about 6 weeks. Opening statements were on August 18th, which on a normal schedule puts a decision somewhere in late September or October. Zuckerberg may testify. As of opening day, the Attorney General hadn't decided whether to call him. Adam Mosseri, who runs Instagram, is also among the expected witnesses. This is one trial out of several. The 4 states arguing this case, California, Colorado, Kentucky, and New Jersey, are the first tranche. The remaining states in that 29-state coalition are expected to get their own trials later. And whatever happens here, it gets appealed. Legal observers broadly expect Meta to appeal any adverse ruling, potentially all the way to the Supreme Court. The company has already said it will appeal the New Mexico verdict. which means even a total loss in Oakland isn't the end. It's the beginning of an appellate process that could run for years, and that could, at the very top, restore everything Section 230 has lost. So let's put the trillion back in its box. $1.4 trillion is Meta's arithmetic, produced by Meta's lawyers, describing a ceiling that will not be reached, and disowned by the Attorney General leading the case on the day the trial opened. The realistic exposure is a fraction of that, and based on what New Mexico and Los Angeles suggest, even a win for the states might produce a number Meta can absorb without changing its behavior at all. The money is the least interesting thing here. What's interesting is the argument underneath it. The idea that the way a product is engineered can itself be a defect, independent of anything a user ever posted. That we built it that way on purpose, and we knew what it did, is a sentence that can now be put to a fact finder instead of dismissed at the door. For 20 years, that sentence never got a hearing. Section 230 ended the conversation before it started. This month, the Ninth Circuit said the shield is a defense, not a door. This week, a federal judge started hearing evidence on whether the design of Facebook and Instagram was defective, and a former engineering director sat in a witness chair and described what he says he told the chief executive, roughly 100 times. None of that has been decided. The trial is ongoing, the allegations remain allegations, and Meta denies them, disputes the framing, and will appeal. But the wall has a door in it now, and every social media company in America is watching to see what happens to the first people who walk through.